Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or real estate advice. Real estate laws, divorce proceedings, and tax implications vary significantly by state and individual circumstances. You should not rely on this content as a substitute for the advice of a qualified attorney, accountant, or licensed real estate professional in your specific jurisdiction. Any mention of historical trends or case studies is intended to illustrate general concepts and does not reflect a potential outcome for your specific situation. Always conduct your own due diligence before making significant financial or legal decisions. The biggest financial catastrophe in the United States does not happen on the floor of the New York Stock Exchange, and it does not happen during a national housing market crash. It happens in a quiet living room when a husband and wife, facing the dissolution of their marriage, realize that their primary residence, the largest asset they own, has become a weapon used for mutual destruction. In many high-conflict divorces, the family home is not just a piece of real estate. It is a $500,000 or $5 million hostage. According to historical trends in U.S. Census data and family court filings, nearly 50% of marriages end in divorce, and in the vast majority of those cases, the equity in the home represents over 70% of the couple's total net worth. Yet, most couples make the critical mistake of hiring a standard residential real estate agent, perhaps a friend, a neighbor, or a top producer from their local firm, who has absolutely no training in the complex, high-stakes intersection of family law and property liquidation. This single decision can lead to the loss of hundreds of thousands of dollars in equity, years of unnecessary litigation, and the permanent scarring of family relationships. Today, we are launching a deep dive masterclass into the specialized world of the divorce real estate agent. This is not about simple sales. This is an academic discourse on the specialized protocols required to navigate the sale of a marital asset under the shadow of a court order. This video series solves the most pressing problem facing divorcing homeowners today: the vacuum of professional neutrality. We are going to explore how a certified divorce real estate expert, or CDRE, operates within the U.S. legal system to prevent the house from being sold for pennies on the dollar, how they manage the explosive emotions of two parties who cannot stand to be in the same room, and how they protect the equity that both parties need to start their new, separate lives. To understand the gravity of this niche, we must first analyze the sociological shift that occurred in the United States following the passage of the 1970 No-Fault Divorce Act in California, which eventually swept across the nation. Prior to this, the legal system required a guilty party, which often dictated how assets were divided. In the modern era of equitable distribution and community property states, the home has become the central battlefield for settling the score. A standard real estate agent is trained to be a fiduciary for their client, but in a divorce, there are two clients with diametrically opposed goals. One spouse may want to sell quickly to move on, while the other may want to delay the sale to remain in the home or out of spite. When a standard agent is caught in the middle, they often inadvertently choose a side, which can lead to a breach of fiduciary duty, legal motions to disqualify the agent, and a complete stall in the sale process. Historical trends in family law show that when a real estate agent is not trained in divorce protocols, the days on market for a marital home can be triple the local average. This is not due to the house being unattractive, but because the internal conflict prevents showings, prevents repairs, and leads to rejected offers that should have been accepted. For example, consider a case study where a husband refuses to sign a listing agreement because he feels the price is too low, while the wife is desperate to sell because she cannot afford the mortgage payments on her own. A standard agent might try to convince the husband, which he perceives as the agent teaming up with his wife. The result? A stalemate that ends in foreclosure. In contrast, a specialized divorce real estate agent understands that their role is not just to sell a house, but to manage a legal process. They are trained in the specific language of the court, they understand the implications of a lease pendens, and they know how to communicate with two opposing attorneys to ensure that every step of the sale is documented and defensible in front of a judge. The complexity deepens when you realize that in many U.S. jurisdictions, the real estate agent can be called as an expert witness. Imagine a traditional agent being subpoenaed to testify about why the house didn't sell. If they have kept poor records or have been seen as biased toward one spouse, their testimony could be used to penalize one party financially. A divorce real estate specialist, however, maintains a neutrality log, a meticulous record of every communication, every showing, and every obstacle created by either party. This level of detail is not taught in standard real estate licensing courses. It is a specialized discipline that bridges the gap between the local multiple listing service and the hallowed halls of the family court. In this masterclass, we will break down the three distinct pillars of the divorce real estate agent's responsibility. First is the legal pillar, where the agent must navigate court orders, appointment of a receiver, and the specific timelines mandated by a judge. Second is the financial pillar, which involves understanding the tax consequences of the sale of a primary residence under Section 121 of the Internal Revenue Code, specifically how the $250,000 or $500,000 exclusion applies when the couple is no longer filing jointly. Third is the psychological pillar, which involves de-escalating conflict so that the asset can actually be shown to potential buyers without the stink of divorce ruining the value. Many viewers may think, why not just wait until the divorce is final to sell the house? Historical trends suggest that this is often financially impossible. The carry cost of a marital home, the mortgage, taxes, insurance, and maintenance, is often predicated on a dual-income household. Once the household splits, the burn rate of their combined savings accelerates. The house must be sold, and it must be sold for top dollar to provide both parties with the nest egg required to secure two new residences. This is the high-stakes environment where the divorce real estate agent operates. They are the special ops of the real estate world, entering a high-conflict zone with the sole mission of extracting the maximum amount of equity, while the building is metaphorically on fire. Throughout this series, we will examine the specific mechanics of the three-way conflict: spouse A versus spouse B, the spouses versus the market, and the attorneys versus the timeline. We will look at step-by-step details on how a neutral agent handles a situation where one spouse refuses to leave the house for showings, or worse, deliberately sabotages the home's curb appeal to drive down the price so they can buy out the other spouse at a discount. These are not hypothetical scenarios. They are the daily reality of the divorce real estate niche in the USA. By the end of this deep dive, you will understand why this specialization is the most critical, yet least understood, component of the modern American divorce process. We are going to peel back the curtain on how professionals protect the American dream, even when the marriage behind it has become a nightmare. To understand why a specialized professional is required, we must first analyze the fundamental flaw in standard real estate training when applied to the family law courtroom. In a traditional transaction, a real estate agent is taught to be a cheerleader for the property and a fierce advocate for their client. However, in the high-stakes environment of a U.S. divorce in 2026, advocacy for one party is often legally interpreted as hostility toward the other. This is the first concept we must master: the neutrality doctrine. A certified divorce real estate expert, or CDRE, does not represent the husband or the wife. They represent the equity of the home and the orders of the court. This distinction is not merely semantic. It is a mechanical requirement that prevents the entire sale from collapsing under the weight of litigation. Imagine a scenario in 2026. We will look at a case study involving a couple named Michael and Sarah living in Austin, Texas. They purchased their home in 2018 for $400,000. By early 2026, despite a stabilizing market, the home is valued at $850,000. They have nearly $500,000 in liquid equity. Sarah has already moved into an apartment and is eager to sell to fund her new life. Michael, however, remains in the marital home. He is comfortable, his commute is short, and he feels that if he delays the sale long enough, Sarah might settle for a lower payout just to be done with the process. In this instance, a traditional real estate agent would likely be hired by Sarah. When that agent calls Michael to schedule a photo shoot or a showing, Michael views that agent as Sarah's henchman. He refuses entry, claims the house is messy, or simply ignores the emails. In historical trends, this is where the standard agent fails. They attempt to use sales tactics on Michael. They try to convince him that selling now is good for his credit. But Michael is not motivated by credit. He is motivated by a complex web of grief, anger, and a desire for leverage. The specialized divorce real estate agent approaches Michael and Sarah differently. From day one, the agent establishes a communication matrix. This is a step-by-step protocol where every email, text, and phone call is sent to both parties and both of their attorneys simultaneously. There are no side conversations. There is no favoritism. By removing the possibility of secret alliances, the agent begins to neutralize the suspicion that fuels Michael's resistance. Step 1 in this deep dive is the appointment process. In the U.S. legal system, A divorce real estate agent can be brought into a case in 3 ways. The first is by mutual agreement of the parties, which is rare in high-conflict cases. The second is through a recommendation by the attorneys when they realize the property is too volatile for a standard agent. The third and most powerful is a court appointment, under laws similar to Rule 70 of the Federal Rules of Civil Procedure, which allows a judge to appoint a third party to perform a specific act if a person fails to comply with a court order. A judge can sign an order naming a specific agent to sell the home. This order often grants the agent the authority to sign listing documents on behalf of a non-cooperative spouse. Let us look at the data regarding court-involved sales. Historical trends in major metropolitan areas like Los Angeles, Chicago, and Miami show that when a house is sold under a specific, detailed court order rather than a vague directive to sell, the final sales price is consistently higher. This is because a detailed order removes the power of a sabotaging spouse. The order will specify exactly which agent is in charge, how the price will be determined, who will pay for repairs, and what the consequences are for blocking a showing. The divorce real estate agent acts as the eyes and ears of the court. If Michael in our Austin case study refuses to let a buyer in, the agent does not argue with him. Instead, the agent documents the refusal in a neutrality log. The neutrality log is a critical tool that we must examine. This is a chronological record of every interaction related to the sale. It includes timestamps of when showing requests were sent, when they were acknowledged, and if they were declined, what reason was given. If Michael claims the house was not shown because the agent was lazy, the agent can produce the log in court showing that Michael declined 12 showings in a 14-day period. This data-driven approach shifts the narrative from he said she said to objective fact. In 2026, where digital footprints are everything, the neutrality log serves as the ultimate protection for the home's equity. Now, consider the technical complexity of the listing agreement in a divorce context. A standard agreement assumes both sellers are aligned. A divorce listing agreement often requires specific addendums. For example, the agent must address how the lockbox will be handled. Will there be a restricted showing window to accommodate children's schedules? How will the signatures be captured? In many 2026 transactions, the parties refuse to use the same digital signature platform session. The agent must facilitate separate signings to ensure that neither party feels pressured or monitored by the other. Furthermore, the agent must be prepared for the expert witness role. If Michael's attorney challenges the listing price, claiming the agent is underpricing the home for a quick sale, the specialized agent must be ready to take the stand. They must present a comparative market analysis that is not just a marketing fluff piece, but a forensic evaluation of value that can withstand cross-examination. They must explain the absorption rate in the Austin market, the impact of current interest rates on buyer pool depth, and why the specific condition of the marital home, perhaps neglected during the emotional turmoil of the separation, dictates the chosen price point. We must also discuss the role of the agent in property preparation. Imagine if Michael, in a fit of frustration, decides to stop mowing the lawn or intentionally leaves the house smelling of pets during a high-value showing. A standard agent might feel awkward addressing this. A divorce specialist, however, has a pre-negotiated repair and maintenance schedule, approved by the attorneys or the court. If the lawn is not mown, the agent has the authority to hire a service and have the cost deducted from the non-compliant party's share of the proceeds at closing. This is not about being a gardener. It is about protecting the asset from what is known as waste. In legal terms, waste occurs when a party in possession of a property allows its value to decrease through neglect or intentional acts. As we move deeper into this masterclass, we begin to see that the divorce real estate agent is a hybrid professional, part real estate expert, part legal liaison, and part conflict manager. They operate in a world where the standard rules of sales are inverted. Success is not measured by a bottle of champagne at the closing table, as the parties will likely not be celebrating together. Success is measured by the successful transfer of title and the preservation of equity that allows two individuals to achieve a clean break. The weight of this responsibility cannot be overstated. In the United States, for the average family, the equity in their home is the difference between a secure retirement and financial instability. When that equity is threatened by the friction of a divorce, the specialized agent is the only barrier between a successful sale and a catastrophic foreclosure. But what happens when the problems aren't just between the husband and the wife? What happens when the house itself has secrets that only one spouse knows? Or when external creditors are lurking in the shadows, waiting to pounce on the proceeds before the parties can even see a dime? In the next part, we will explore the hidden financial traps that can derail a divorce sale, including surprise liens, judgments, and the terrifying reality of the title search in a contested dissolution. We will look at how a professional identifies these landmines before they explode at the closing table. The title search is the forensic autopsy of a real estate transaction. In a standard sale, the preliminary title report is often treated as a formality, a document reviewed by an escrow officer in the final days before closing. However, in the high-stakes ecosystem of a 2026 divorce sale, treating the title report as an afterthought is a recipe for financial disaster. The specialized divorce real estate agent views the title report as the very first line of defense. This document reveals the hidden reality of the marital estate, often surfacing debts and legal encumbrances that one or both spouses have kept hidden during the mediation process. Imagine a scenario in 2026 involving a couple named Robert and Jennifer in Seattle, Washington. They have lived in their family home for 15 years, and on paper, the property is worth $1.4 million with a remaining mortgage of only $400,000. During their initial divorce filings, both parties agreed that there was approximately $1 million in equity to be split. Jennifer plans to use her half to purchase a small townhouse, while Robert intends to move into a high-end rental while he stabilizes his post-divorce life. A standard real estate agent would look at these numbers, list the property, and wait for an offer. But a professional specializing in divorce real estate orders a preliminary title report the moment the listing agreement is signed. The report comes back, and the diagnostic results are devastating. It reveals a $125,000 IRS tax lien filed against Robert's Social Security number from a failed business venture 2 years prior. Additionally, there is a $45,000 mechanics lien from a contractor who performed unpermitted basement work in 2024 that Robert never fully paid for. Most shockingly, the title report shows an abstract of judgment for $30,000 from a private creditor. Suddenly, the $1 million in expected equity has shrunk by $200,000 before the house has even hit the market. In the U.S. legal framework, these liens attach to the property itself, not just the individual, depending on whether the state follows community property or equitable distribution laws. In a community property state like Washington, Jennifer might find herself legally and financially responsible for half of those debts, even if she had no knowledge of Robert's business failure or the unpaid contractor. A standard agent would discover this 3 days before the scheduled closing, leading to a collapsed deal, a lawsuit from the buyers, and a catastrophic breakdown in the divorce settlement. A specialist, however, identifies these landmines in week 1. They immediately deliver the title report to both divorce attorneys, allowing the legal teams to adjust the marital settlement agreement to account for the diminished equity before any financial commitments are made. We must also analyze the technical role of the Statement of Information, or the SI. In 2026, with the prevalence of identity theft and the digitizing of public records, title companies require an SI from both spouses. This is a private document where the parties provide their social security numbers, past addresses, and aliases. This allows the title insurer to distinguish between our character Robert and any other Robert in the state of Washington, who might have outstanding child support judgments or unpaid civil fines. If a spouse refuses to sign the SI, perhaps out of a misguided sense of privacy or a desire to hide more debt, the sale stops. The specialized agent understands how to navigate this resistance, often coordinating with the attorneys to have the judge order the release of the information to the title company under a protective seal. Another critical academic concept in divorce real estate is the lease pendens, a Latin term meaning suit pending. In many high-conflict cases, one spouse may file a notice of lease pendens against the marital home. This is a public notice filed in the county records stating that the title to the property is currently being litigated in court. From a market perspective, a lease pendens is a poison pill. Most traditional buyers and their lenders will not touch a property with a clouded title. Historical trends show that properties with a lease pendens can sit on the market for hundreds of days, eventually selling for significantly less than fair market value to predatory cash investors. The professional divorce agent works to ensure that a lease pendens is either withdrawn or that a court order is in place that allows the title company to ensure the sale despite the ongoing litigation. We also have to consider the home equity line of credit, or HELOC. In the economic climate of 2026, many families have used HELOCs to navigate inflation or fund lifestyle expenses. In a divorce, a HELOC is a live grenade. Most HELOCs allow either spouse to draw funds without the other's signature. Imagine if 2 weeks before the house hits the market, Robert decides to draw $50,000 from the line of credit to pay for his new apartment's furniture and legal fees. If the real estate agent has not frozen the account or coordinated with the lender to close the draw period, the equity is being siphoned off in real time. The specialized agent includes a specific instruction in the listing protocol for the attorneys to issue a formal freeze on all credit lines attached to the property. The deep dive analysis of title also involves the payoff demand. This is not just about the principal balance of the mortgage. It includes interest, which in 2026 can be calculated as a daily per diem, escrow shortages, and potential prepayment penalties. If the house sits on the market for an extra 60 days because of a conflict between the spouses, the interest alone could eat another $10,000 of equity. The professional agent monitors these numbers constantly, providing the parties with a net sheet at every price reduction or offer. This net sheet is a step-by-step breakdown of exactly what each spouse will walk away with after all liens, commissions, and taxes are paid. This transparency is what prevents one spouse from feeling cheated at the closing table. Furthermore, we must address the Internal Revenue Code Section 121. While real estate agents are not tax professionals, they must be aware of how a title cloud or a delayed sale impacts the capital gains exclusion. If the divorce takes longer than expected and one spouse has been out of the house for more than 3 of the last 5 years, they may lose their $250,000 tax exclusion. This can result in a massive unexpected tax bill that further erodes the net proceeds. The specialist ensures that the timeline of the sale is synchronized with the tax needs of the clients, often prompting a consultation with a CPA as part of the listing process. As we conclude this analysis of the financial landmines, we realize that the sale of a marital home is less about the structure of the house and more about the structure of the debt. The professional divorce real estate agent is essentially a forensic auditor who happens to have a real estate license. They must possess the technical literacy to read a title report like a map, identifying every lien, judgment, and encumbrance that stands between the parties and their financial freedom. But what happens when the house is finally cleared of its financial ghosts, yet the physical property itself becomes a target? What happens when the walkthrough reveals that the angry spouse has stripped the copper piping, or that the house has been staged to look like a disaster zone to scare off buyers? In the next part, we will move from the paperwork to the pavement. We will explore the physical reality of the listing appointment from hell, how to manage a property walkthrough when the spouses are barred from being in the same zip code, and the specific strategies used to prevent property sabotage before the first showing. The transition from the forensic analysis of a title report to the physical threshold of the marital home is where the academic theories of divorce real estate meet the volatile reality of human emotion. In a standard residential sale, the listing appointment is a social event, often involving coffee, small talk, and a shared vision of a successful future. In a high-conflict U.S. divorce in 2026, the listing appointment is a tactical operation. The professional divorce real estate agent must operate under the assumption that the physical property is not just an asset, but a crime scene of a failed relationship, and every square foot is a potential point of contention. The first mechanical hurdle is the dual listing appointment. Historical trends in family law suggest that in over 60% of contested divorces, the parties cannot or will not be in the same room together. This necessitates 2 completely separate listing presentations. This is not merely for the convenience of the parties, it is a legal safeguard. If an agent meets with spouse A on Tuesday and spouse B on Wednesday, the agent must ensure that the information provided is identical to the letter. Any deviation in the predicted sales price, the commission structure, or the marketing strategy given to one party over the other can be used by an aggressive attorney to allege bias or collusion. The specialist often uses a standardized, pre-recorded digital presentation or a rigorous script to ensure that both David and Lisa, our character study for this part, receive the exact same data set. Imagine David and Lisa in 2026, living in Phoenix, Arizona. A restraining order is in effect, prohibiting David from being within 100 yards of Lisa. Lisa is the occupant of the home, while David is living in a short-term rental. The real estate agent must first coordinate with both legal teams to arrange a walkthrough. This walkthrough is not for the purpose of admiring the architecture. It is a forensic inventory. The agent must determine what constitutes a fixture and what is personal property. This is where we apply the Maria test, a classic real estate acronym that becomes a legal battleground in divorce. The Maria test stands for method of attachment, adaptation, relationship, intention, and agreement. In 2026, The complexity of this test has increased with the prevalence of high-tech smart homes. If David installed a $10,000 integrated home theater system and a series of custom-coded smart locks, Lisa might argue they are fixtures that stay with the house. David might argue they are personal property that he intends to take. The specialized agent must inventory every single one of these items during the walkthrough and present the list to the attorneys. If the agent fails to do this and David removes the smart locks the night before closing, the buyer will refuse to sign, and the sellers may find themselves back in court facing a motion for contempt. The walkthrough also serves as the baseline for preventing property sabotage, or what the legal system calls marital waste. Historical trends show that a spouse who feels they are being forced out of a home may intentionally or subconsciously allow the property to deteriorate. In extreme case studies, this has included pouring concrete down drains, leaving windows open during a monsoon, or removing copper wiring. However, the more common form of sabotage in 2026 is passive-aggressive neglect. This is why the specialist uses high-resolution 3D mapping technology during the initial walkthrough to create a digital twin of the property's current state. This digital record serves as time-stamped evidence. If the property is later found to have new damage, the agent can provide the court with the 3D scan to prove the damage occurred after the listing agreement was signed. Consider a specific case study from early 2026. A husband in a high-conflict divorce was ordered by the court to maintain the home's curb appeal. Instead, he stopped paying the water bill in the heat of a Phoenix summer, causing a $5,000 landscaping package to die within weeks. Because the specialized agent had documented the lush state of the yard at the time of the listing, the wife's attorney was able to successfully petition the judge to credit the wife $5,000 from the husband's share of the home's equity to cover the loss of value. This level of forensic documentation is what separates a divorce real estate professional from a standard salesperson. Beyond physical damage, the agent must manage the psychological presentation of the home, specifically the removal of the personal artifacts of the marriage. In the industry, this is known as the depersonalization protocol. It is an academic fact that buyers in the 2026 market are highly sensitive to the energy of a home. If a buyer walks into a house and sees a wedding photo with one face scratched out, or a half-packed suitcase in the hallway, they immediately sense a desperate sale. This leads to lowball offers, as buyers assume the sellers are in a rush to liquidate. The specialist must navigate the delicate task of telling a grieving or angry spouse that their family photos, their children's height marks on a door frame, and even the smell of their specific pets must be neutralized. Step by step, the agent facilitates the staging process. This often involves hiring a third-party neutral staging company. By using a third party, the agent avoids being the person who tells Lisa that her taste in furniture is hurting the sale. Instead, it becomes a professional recommendation based on market data. The goal is to make the home look like a high-end hotel, neutral, aspirational, and entirely devoid of the conflict that is currently tearing the owners apart. This staging must be maintained consistently. If one spouse is still living in the home, the agent must establish a showing protocol that includes a checklist: dishes away, beds made, and all evidence of the divorce hidden from view. Furthermore, the agent must address the issue of access. In 2026, many homes are equipped with Ring cameras and smart security systems. In a divorce, these tools are often used for domestic espionage. One spouse may use the cameras to monitor who is coming and going, or to listen in on the conversations between the real estate agent and potential buyers. The specialized agent must insist that all internal cameras be disabled or covered during showings to protect the privacy of the buyers and the integrity of the sale. This is a matter of both ethics and liability. The listing appointment and walkthrough phase is essentially about risk mitigation. The agent is identifying every physical and psychological barrier to a top-dollar sale. They are acting as a buffer between two people who can no longer communicate, ensuring that the asset they built together is not destroyed by the emotions of its dissolution. By the time the house hits the multiple listing service, the agent has already performed more work than a standard agent performs in an entire transaction. They have mapped the property, inventoried the fixtures, established a neutrality protocol, and prepared for the inevitable attempts at sabotage. However, even with a perfectly prepared home and a forensic inventory in place, a new challenge arises once the listing goes live. The public market is a harsh judge, and the way a divorce property is perceived by outside buyers can either save the equity or sink it. In the next part, we will explore the market stigma of the divorce sale. We will look at how the phrasing in a listing description can accidentally signal a fire sale, the specialized strategies for handling buyer's agents who smell blood in the water, and the complex art of managing multiple offers when the sellers cannot agree on a single penny of the counteroffer. We will dive into the mechanics of the neutral negotiation framework and how to keep a deal from falling apart when the sellers are using the contract as a final chance to hurt each other. The market stigma of a divorce sale is a tangible financial force that can erode equity as surely as a leaking roof or a cracked foundation. In the hyper-connected real estate environment of 2026, information is the primary currency. When a property is perceived as a distressed asset due to the personal circumstances of the sellers, the buyer pool shifts from traditional families to opportunistic investors. The professional divorce real estate agent must employ a strategy of strategic ambiguity. This means the listing must be presented with the highest level of professional polish to mask the internal turmoil. Historical trends in the 2026 U.S. housing market indicate that listings featuring phrases like motivated sellers or must sell quickly experience an average price reduction of 7 to 10% compared to neutral listings. For $1 million home, that is a $100,000 penalty for a lack of linguistic discipline. The specialized agent carefully constructs the public-facing narrative. Instead of signaling a court-ordered liquidation, the agent focuses on the empirical data of the home. Every word in the multiple listing service description is scrutinized. If the agent mentions that the sellers are looking for a quick closing, they are essentially inviting sharks into the water. In the academic discourse of real estate psychology, this is known as signaling theory. The goal is to signal stability and value, even when the underlying reality is a legal battlefield. Imagine a case study from 2026 involving Marcus and Emily in Denver, Colorado. They are selling a renovated mid-century modern home in a high-demand neighborhood. Marcus is an engineer who values cold logic and wants the absolute highest price to recoup his investment in the kitchen remodel. Emily is a healthcare administrator who is exhausted by the 2-year divorce process and simply wants to accept any offer that allows her to move to her new condo. A standard agent would be caught between Marcus's stubbornness and Emily's desperation. In this scenario, a buyer's agent, sensing the friction during a showing, might submit an offer that is $50,000 below asking price, with a 48-hour expiration window. They are betting that Emily's desire to be done will force Marcus to fold. The specialized agent counters this through a neutral negotiation framework. This framework is built on 3 specific step-by-step protocols. The first is the simultaneous offer delivery. In 2026, this is often handled through a secure digital portal where both Marcus and Emily receive a notification of an offer at the exact same millisecond. This prevents one party from having a head start in forming an opinion or attempting to influence the agent before the other party has seen the terms. The second protocol is the objective summary sheet. The agent does not just send the contract. They send a spreadsheet that strips away the emotional weight of the offer. It breaks down the net proceeds for each party, the strength of the buyer's financing, the length of the inspection period, and the potential outcomes of a counteroffer. The third protocol is the reasonableness test. When Marcus wants to reject a fair offer out of spite because Emily likes it, the agent introduces historical market trends. They show Marcus that in the current 2026 Denver market, homes that reject an offer within 5% of the asking price typically stay on the market for an additional 45 days and eventually sell for 3% less than the initial offer. By shifting the conversation from Emily wants this to the data suggests this is your peak equity point, the agent provides Marcus with a logical off-ramp that preserves his ego while protecting the collective equity. Furthermore, we must analyze the role of the buyer's agent. In a standard sale, the 2 agents often collaborate to get the deal done. In a divorce sale, the buyer's agent is often searching for leverage. They may look for clues during the walkthrough. 2 different brands of toothpaste in separate bathrooms, 1 closet completely empty, or a calendar on the fridge with court dates marked in red. The specialized divorce agent conducts a pre-showing sweep to ensure these breadcrumbs are removed. They also establish a strict communication rule. All inquiries from buyer's agents regarding the seller's motivation are met with a standardized, professional response. The sellers have decided to move in different directions and are focused on a smooth, professional transaction at fair market value. This prevents the leaking of sensitive information that could be used against the parties at the negotiating table. Another complex layer is the management of multiple offers. Imagine if Marcus and Emily receive 4 offers. One is the highest price but has a risky financing contingency. Another is all cash but significantly lower. A third is from a family that Emily feels a sentimental connection to. while Marcus wants the highest bidder regardless of the risk. A standard agent might inadvertently take a side, but the specialist uses a weighted scoring matrix. This matrix assigns points to each offer based on the certainty of closing, the net proceeds, and the timeline. By presenting the offers as a ranked list based on pre-agreed criteria, the agent forces the sellers to engage with the reality of the market rather than their personal feelings toward each other or the buyers. This is where we must also discuss the earnest money deposit, or EMD. In a high-conflict divorce, the EMD is not just a deposit, it is a point of potential hostage-taking. If a deal falls through because one spouse refuses to sign a repair addendum, the question of who gets the EMD can lead to a secondary lawsuit. The specialized agent ensures that the language in the listing and the counteroffers is extremely specific about the release of funds and the mediation process. They work to minimize the variables that could give one spouse a way to sabotage the deal in the 11th hour. In 2026, the use of a neutrality log becomes essential during the negotiation phase. If Emily is being reasonable but Marcus is ignoring the agent's calls to review an offer that expires in 6 hours, the agent documents every attempt to reach him. This log is sent to both attorneys. This is not about tattling. It is about providing the legal teams with the evidence they need to perhaps seek a localized emergency order, or to ensure that the non-responsive party is held financially liable for any lost equity resulting from their delay. The mere existence of this log often encourages a level of cooperation that would not otherwise exist. The negotiation phase of a divorce sale is essentially a high-stakes chess match where the agent is playing against the market on one side, and the seller's own destructive impulses on the other. The goal is to move the pieces toward a stalemate that actually results in a win for both parties, the liquidation of the asset at the highest possible value with the lowest possible legal risk. It is a process that requires a deep understanding of contract law, market analytics, and the dark corners of human psychology. But even after a contract is signed and the price is agreed upon, the most dangerous phase of the entire process begins. We are entering the inspection and repair gauntlet. This is where the deal is most likely to die. What happens when the inspector finds a $10,000 mold issue and neither spouse is willing to pay for it? What happens when one spouse tries to use the repair negotiations to force the other back to the mediation table? In the next part, we will dive into the forensic reality of the home inspection in a divorce. We will look at how to manage repairs when there is no money in the marital pot, the specialized use of escrow holdbacks to bypass seller conflict, and the technical details of the Section 1031 exchange and how it can be a secret weapon for divorcing investors or a trap for the unwary. The home inspection is often referred to in academic real estate circles as the truth serum of a transaction. In a standard sale, it is a period of negotiation. In a 2026 divorce sale, it is a period of high-stakes interrogation. This phase represents the greatest statistical probability of a deal collapsing. When an inspector identifies a latent defect, perhaps a foundational crack or a failing sewer line, it forces a financial confrontation between two people who may already be struggling to agree on the time of day. The professional divorce real estate agent must navigate this by treating the inspection report not as a list of problems, but as a series of binary legal decisions that must be channeled through the attorneys. Imagine a case study involving Thomas and Sandra in 2026, selling their family home in suburban Atlanta. The inspector discovers that the roof, while visually acceptable, has suffered significant hail damage that was never reported to insurance, and the cost of replacement is estimated at $22,000. Thomas, who has been paying the mortgage, refuses to contribute a single cent to the repair, arguing that Sandra should have noticed the leaks months ago. Sandra, who has already moved out, refuses to allow the repair costs to come out of her half of the equity. A standard agent would likely find themselves stuck in an endless loop of emotional arguments. The specialized agent, however, employs a specific repair protocol designed for gridlock. Step 1 is the solicitation of 3 independent, licensed contractor bids. By providing 3 options rather than 1, the agent removes the accusation of favoritism toward a specific vendor. Step 2 is the presentation of the marketability impact study. The agent provides Thomas and Sandra with data showing that in the 2026 Atlanta market, a home with a known roof defect will see a reduction in buyer interest by over 40%, often resulting in a price drop far exceeding the $22,000 repair cost. This shifts the focus from who is right to what preserves the most equity. If the parties still cannot agree on an upfront payment, which is common when liquid cash is tied up in legal fees, the agent introduces the mechanical solution of the escrow holdback. This is a specialized legal arrangement where a portion of the seller's proceeds is set aside at the time of closing to be held by the title company. The repair is then performed after the sale, paid for directly from those held funds. In 2026, lenders have become increasingly strict, but historical trends show that many will allow an escrow holdback if it is funded at 150% of the estimated repair cost to provide a safety margin. This allows the transaction to move forward to the closing table without requiring the sellers to produce cash they do not have or talk to each other to coordinate a contractor. Beyond physical repairs, the academic discourse on divorce real estate must address the complexities of the investment property, specifically the Section 1031 exchange. While Section 121 of the Internal Revenue Code covers the primary residence exclusion, many divorcing couples in the United States also own rental properties or commercial assets. A 1031 exchange allows an investor to defer capital gains taxes by reinvesting the proceeds from a sale into a like-kind property. In a divorce, this becomes a technical minefield. The primary challenge is the same taxpayer rule. To qualify for a 1031 exchange, the entity that sells the property must be the same entity that purchases the replacement property. If Thomas and Sandra own a rental property as a married couple or through a joint LLC, and they wish to split up and each buy their own separate investment properties, they risk violating the like-kind requirements and triggering a massive tax liability. This is where the specialized agent coordinates with a qualified intermediary, or QI. In 2026, the strategy often used is the swap or drop. This involves either swapping the interests before the sale so each party owns a tenant-in-common interest that can be exchanged independently, or dropping the property out of an LLC into the individual names of the spouses before the transaction begins. The timing here is critical. If the drop happens too close to the sale, the IRS may argue that the individuals did not hold the property for investment purposes, but rather for the purpose of sale, which could disqualify the tax deferral. The professional agent ensures that these conversations happen months in advance, working in lockstep with the couple's tax professionals to ensure the 180-day exchange period and the 45-day identification period are strictly managed. We must also examine the trap of the boot. In 1031 parlance, boot is any non-like-kind property received in an exchange, such as cash or a reduction in mortgage debt. If the divorcing couple uses some of the sale proceeds to pay off personal credit card debts or legal fees before reinvesting the rest, that portion is immediately taxable. For a 2026 investor, failing to account for the boot can lead to an unexpected tax bill that consumes the very liquidity they were trying to preserve. The specialist agent provides a detailed net sheet that highlights where the boot may occur, allowing the attorneys to factor that tax hit into the final distribution of assets. Furthermore, the agent must be a master of the Section 121/1031 overlap. Historically, many couples have converted a former primary residence into a rental property or vice versa. If Thomas and Sandra lived in their home for 3 years, then rented it out for 2 years before the divorce, they may be eligible for both the primary residence exclusion and a partial 1031 exchange. This is known as a mixed-use or split-treatment transaction. The ability to navigate these overlapping codes is what allows a divorce real estate specialist to save their clients tens, if not hundreds of thousands of dollars in avoidable taxes. The inspection and tax phases of a divorce sale are essentially the technical heart of the masterclass. It is where the agent moves beyond being a salesperson and becomes a strategic consultant. They are managing the physical integrity of the asset through inspections and repairs, and the financial integrity of the proceeds through sophisticated tax planning. Every step is documented, every bid is vetted, and every tax implication is flagged for the legal teams. This level of depth ensures that the parties do not just sell a house, but they exit the investment with their financial future intact. However, even with the repairs managed and the tax strategy set, the transaction faces one final, insurmountable hurdle: the human element of the closing. The closing is the moment of no return. It is the moment when the deed is signed, the keys are handed over, and the marriage is officially decoupled from the property. But what happens when a spouse gets cold feet at the very last second? What happens when one party refuses to sign the final closing disclosures because they realize they have nowhere to go? In the next part, we will explore the psychology of the closing table. We will look at the mechanics of the separate signing, the prevention of the last-minute holdout, and the specialized role of the mobile notary in high-conflict scenarios. We will also dive into the terrifying reality of the post-closing occupancy agreement, and why letting a divorcing spouse stay in the home after the sale is the most dangerous move an agent can make. The closing process in a traditional real estate transaction is often a celebratory milestone, but in the academic study of divorce real estate, the closing is the ultimate friction point. It is the moment where the abstract concept of a house sale transforms into the irreversible reality of a severed life. In 2026, the professional divorce real estate agent must treat the 72 hours leading up to the closing as a high alert period for technical and psychological failures. The primary tool used to navigate this is the separate signing protocol. Historical trends indicate that forcing two divorcing spouses into the same title office, even in separate rooms, can lead to emotional outbursts that cause the title officer to halt the proceedings due to concerns about duress or lack of sound mind. A specialized agent coordinates with the escrow officer to ensure that the parties never cross paths. This often involves scheduling signings on different days or, more frequently in 2026, employing the use of specialized mobile notaries. Imagine a case study in Philadelphia involving James and Olivia. James has been living in the marital home throughout the listing period, while Olivia has been renting a small apartment across town. As the closing date approaches, James begins to exhibit what psychologists and real estate experts call the last-minute holdout. This is not driven by a desire for more money, but by the paralyzing realization that once the deed is signed, the final physical tie to his marriage is gone. From a technical standpoint, James might suddenly refuse to sign the closing disclosure or CD. Under current U.S. regulations, specifically the TILA-RESPA integrated disclosure rules, the buyer must have at least 3 business days to review the CD before they can sign their loan documents. If James delays his signature on the CD by even 6 hours, he can push the entire closing back by several days, potentially causing the buyer's interest rate lock to expire. The specialized divorce agent manages this by utilizing the alternative outcome analysis. Instead of pleading with James to sign, the agent presents a data-driven breakdown of the consequences of a delay. This includes the per diem interest cost to the buyer which James may be liable for, the potential for the buyer to sue for specific performance, and the likelihood of the divorce attorneys filing an emergency motion for a petition referee or a receiver. In the U.S. legal system, a receiver is a court-appointed official who takes full control of the asset. Historical trends show that receivership can cost the marital estate between 5% and 10% of the home's value in additional fees. By framing the signature as a choice between a controlled exit and a financially ruinous court-mandated takeover, the agent provides James with a logical framework to overcome his emotional paralysis. We must also analyze the role of the mobile notary in this environment. A standard mobile notary simply witnesses a signature. A notary trained in high-conflict divorce real estate operates as a neutral observer who is briefed on the specific sensitivities of the case. They are instructed to look for signs of cognitive dissonance and to ensure that the person signing is doing so without immediate physical or emotional threat. In our 2026 scenario, the agent might arrange for the notary to meet James at a neutral location, such as a private office suite, while Olivia signs her documents at the title company's main office. This separation ensures that the paperwork is executed without the potential for a confrontation that could jeopardize the entire transaction. However, the most dangerous technical maneuver in a divorce sale is the post-closing occupancy agreement, often referred to in the industry as a rent-back. In a standard market, a buyer might allow a seller to stay in the home for 30 days after closing to facilitate their move. In a divorce, this is a catastrophic risk that the specialized agent must work to eliminate. Imagine if James, after the sale is finalized, refuses to move out. The buyer now owns the home but cannot move in. Because the sale has closed, the divorce real estate agent's formal role has ended, and the buyer is left with the tenant they must legally evict. In 2026, eviction processes in many U.S. jurisdictions can take months. Case studies from 2026 highlight the phenomenon of the occupancy sabotage. In one instance, a departing spouse agreed to a 3-day rent-back, but used that time to remove high-value fixtures that were specifically included in the contract, such as custom cabinetry and built-in appliances. Because the buyer had already funded the loan and the seller had received their proceeds, the buyer's only recourse was a separate civil lawsuit. To mitigate this risk, the professional divorce agent establishes a vacant on closing mandate. This means the house must be completely empty and professionally cleaned before the final walkthrough and before the deed is recorded. If James is still in the house 24 hours before closing, the agent alerts both attorneys, who may then hold the signing of the final documents until the property is verified as vacant. Another layer of the closing process is the management of the final walkthrough. This is the buyer's last opportunity to verify that the home is in the same condition as it was when they made their offer. In a high-conflict divorce, the walkthrough can be a minefield. The agent must conduct a pre-walkthrough sweep to ensure that the departing spouse has not left behind trash, unwanted furniture, or, in extreme cases, hazardous materials. If the house is not in the contractually agreed-upon condition, the buyer may refuse to close. The specialist agent often recommends a specific dollar amount, a repair escrow, to be held back from the seller's proceeds if the house is not clean or if minor damage occurred during the move. This prevents the entire deal from falling apart over a $1,000 cleaning bill. Step by step, the agent facilitates the transfer of keys. In a divorce, the transfer of keys is not a handshake. It is a documented chain of custody. The agent collects all keys, garage door openers, and smart home access codes from the departing spouse and delivers them to the buyer's agent, only after the county recorder's office has confirmed the transfer of title. This meticulous attention to detail prevents any allegations from either spouse that the other returned to the property after the sale to cause damage or remove items. The closing is the final act of the real estate drama. But for the divorcing couple, it is the beginning of their new financial reality. The agent has successfully navigated the title search, the market stigma, the negotiation gridlock, and the psychological hurdles of the signing table. They have protected the equity and ensured that the asset was liquidated for its highest possible value. But as the wire transfers are initiated and the proceeds leave the escrow account, a new and final complication arises. Where does the money actually go? In most U.S. divorces, the distribution of proceeds is not a simple 50-50 split. There are credits for separate property, deductions for marital waste, and set-asides for legal fees and tax liabilities. If the real estate agent has not worked with the escrow officer to ensure the distribution instructions are precise and court-approved, the money can be frozen in limbo, leading to a final, explosive round of litigation. In the next part, we will dive into the complex world of the final distribution of proceeds. We will look at the mechanics of the qualified domestic relations order, the trap of the unrecorded lien, and how the agent ensures that the money actually reaches the parties in a way that aligns with the final judgment of dissolution. We will also explore the terrifying reality of the post-sale audit, and how an agent's records can be the only thing standing between a client and a massive IRS penalty. The distribution of proceeds is the final mechanical gear in the machine of a 2026 divorce real estate transaction, yet it is often the most poorly lubricated. While the closing involves the transfer of the deed and the signing of the loan documents, the actual movement of funds from the escrow account to the individual parties is governed by a complex web of legal mandates, tax reporting requirements, and historical trends in debt priority. In the United States, the specialized divorce real estate agent does not simply walk away once the keys are handed over. They must ensure that the financial exit strategy is executed with forensic precision to prevent what is known as the post-closing litigation loop. To understand the stakes, consider a case study from mid-2026 involving Kevin and Sarah in Chicago, Illinois. They are selling a historic brownstone with $600,000 in net equity. In a traditional sale, a single wire transfer for the full amount would be sent to a joint bank account. In a divorce, this is a catastrophic error. Historical trends in family law suggest that if $600,000 hits a joint account where both parties have access, one spouse may attempt to withdraw the entire sum as leverage for other issues in the divorce, such as custody or alimony. This leads to an immediate freeze of the funds by the court and thousands of dollars in additional legal fees. The professional divorce agent works with the escrow officer to ensure that the preliminary settlement statement, known as the ALTA or the closing disclosure, specifically outlines the split wire instructions. This means two separate wires are initiated to two separate, individual accounts at the moment of recording. However, the calculation of those two wires is rarely a simple 50-50 division. This is where we must dive into the academic concepts of Epstein credits and Watts charges. Although these terms originated in California case law, the underlying principles are applied across most U.S. jurisdictions in 2026 to ensure equitable distribution. An Epstein credit refers to a reimbursement for a spouse who used their separate property funds, perhaps from an inheritance or post-separation earnings, to pay for community expenses like the mortgage or necessary home repairs. In our Chicago case study, Imagine Kevin stayed in the brownstone for 12 months after the separation and paid the $4,000 monthly mortgage entirely from his new salary. He may seek a credit of $24,000 from Sarah's share of the equity at the closing table. Conversely, we have What's charges, which involve the fair market rental value of the home. If Kevin had exclusive use of the $600,000 asset while Sarah had to pay for a separate apartment, the court may determine that Kevin owes the marital estate for the value of that occupancy. If the brownstone could have rented for $5,000 a month on the open market in 2026, Kevin might be charged $60,000 for his year of residency. The specialized real estate agent provides the empirical data, the rental market analysis, and the history of mortgage payments that allows the attorneys to calculate these offsets. Without this data, the distribution of proceeds becomes a guessing game that invites a judge to intervene, often delaying the payout by months. Step by step, the professional agent also monitors for the shadow debt. This refers to unrecorded liens or personal judgments that do not appear on a traditional title search, but can be discovered by a sophisticated creditor the moment they see a for sale sign on the property. In 2026, the speed of digital public records means that a creditor for a personal credit card debt or a medical bill can file a last-minute abstract of judgment. If the escrow officer is not alerted to these potential outcomes, the wire transfer could be intercepted by a third-party creditor, leaving one spouse with nothing. The specialist agent performs a final bring-down search of the public record 24 hours before the wire is sent to ensure no new clouds have appeared on the title. We must also address the terrifying reality of IRS Form 1099-S. This is the document that reports the proceeds of a real estate sale to the federal government. In a standard sale, the 1099-S is often issued to the primary person on the title. In a 2026 divorce, this creates a massive tax liability trap. If the 1099-S reports $1.2 million in gross proceeds to Kevin alone, the IRS will expect Kevin to account for the entire gain on his tax return. If Kevin and Sarah are now filing as single or head of household, Kevin can only exclude $250,000 of gain under Section 121 of the Internal Revenue Code. He would then be taxed on the remaining hundreds of thousands of dollars, even if half of that money went to Sarah. The specialized agent ensures the escrow officer performs a split 1099-S reporting. This involves issuing two separate forms, each reflecting the specific portion of the proceeds received by each spouse. This ensures that both Kevin and Sarah can utilize their individual $250,000 tax exclusions, potentially saving the couple over $100,000 in avoidable federal taxes. Furthermore, we must examine the role of the Qualified Domestic Relations Order, or QDRO, when it intersects with real estate. In some 2026 cases, the equity in the home is used to offset a lopsided retirement account. If Sarah has a pension worth $500,000 and the house has $500,000 in equity, the parties may agree that Kevin takes the house equity while Sarah keeps her pension. However, the real estate agent must verify that this equity swap is documented in the final court order provided to escrow. If the agent allows the sale to proceed without a clear, court-stamped instruction on how to handle the swap, the escrow officer may be legally bound to distribute the funds 50-50 regardless of the parties' verbal agreement. The specialist agent acts as the final gatekeeper, ensuring the paperwork in the escrow file matches the reality of the legal settlement. The depth of this masterclass now moves into the post-sale audit. Even after the funds are distributed, the real estate agent's records remain the primary defense in any future tax or legal challenge. Historical trends show that the IRS is increasingly scrutinizing divorce liquidations to ensure that the primary residence exclusion wasn't used fraudulently on investment properties. The agent's file, containing the neutrality log, the history of showings, the contractor bids for repairs, and the 1099-S instructions, serves as a forensic map of the transaction. If Sarah is audited in 2028 regarding her 2026 tax return, the real estate agent's documentation of the Epstein credits and the split 1099 is the only thing that will prevent a massive penalty. As we analyze the final moments of the money trail, we realize that the divorce real estate agent is essentially a financial bodyguard for the equity. They are protecting the money from aggressive creditors, from the unintentional errors of escrow officers, and from the tax-related pitfalls of the Internal Revenue Code. The successful distribution of proceeds is the silent victory of the specialist. It is the moment when the marital estate finally ceases to exist and becomes the individual capital that will fund two new lives. But the process does not truly end when the bank account balance increases. There is a lingering phenomenon known as the long tail of liability. What happens when the new buyer discovers a defect 3 months after the closing and decides to sue? In a divorce, who is liable? Which spouse pays for the defense? And more importantly, how does a professional agent insulate themselves and their clients from the post-sale nightmare that can drag former spouses back into a courtroom years after they thought they were free? In the next part, we will explore the final legal defenses of the divorce sale. We will look at the mechanics of the as-is clause in a high-conflict context, the specialized use of seller carrybacks in a high-interest 2026 market, and the professional protocols for closing the file to ensure that the divorce real estate agent never becomes a witness in a future malpractice suit. The transition from the distribution of proceeds to the absolute termination of the listing file is where many standard real estate practitioners make their most significant errors in risk management. In the academic study of United States real estate law, there is a concept known as the long tail of liability. This refers to the period after the closing during which the sellers remain legally exposed to claims from the buyer regarding non-disclosure, misrepresentation, or breach of contract. In a 2026 high-conflict divorce, this tail is not just long, it is barbed. Because the sellers are often no longer on speaking terms, a post-closing lawsuit can act as a proxy war, dragging both parties back into the courtroom for years. The professional divorce real estate agent must implement a terminal protocol that insulates the parties from these potential outcomes, while simultaneously protecting their own professional standing. To understand the mechanics of post-closing liability, we must first dismantle the myth of the as-is sale. In many 2026 transactions, divorcing couples insist on listing the property as is to avoid the cost and conflict of repairs. However, in the U.S. legal framework, as is does not mean without disclosure. Imagine a case study involving a couple named Michael and Sophia in Miami, Florida. During the 2026 hurricane season, a small leak developed in the secondary bedroom. Michael, who was living in the home, patched the ceiling with paint but did not perform a structural repair. Sophia, living elsewhere, was entirely unaware of the leak. They sold the home as is to a young family. 3 months after the closing, a major storm reveals the structural damage, and the new owners sue for fraudulent concealment of a material fact. In this scenario, Michael and Sophia face joint and several liability. This means the buyer can pursue either or both of them for the full amount of the damages. If Michael has already spent his share of the proceeds on a new business venture, while Sophia has her share sitting in a high-yield savings account, the buyer's attorney will likely target Sophia's liquid assets first. Sophia then has to sue Michael for indemnification, a legal process that can cost more than the original repair. The specialized divorce agent prevents this by insisting on a comprehensive seller property questionnaire and a real estate transfer disclosure statement that is signed by both parties. If Michael refuses to disclose the leak, the agent's neutrality log becomes the primary evidence. The agent documents that Michael was asked specifically about water intrusion and denied it. This shifts the liability away from the innocent spouse and the agent, providing a clear map for legal teams to follow. Beyond the physical condition of the home, 2026 has seen a resurgence in a complex financial maneuver known as the seller carryback, or seller financing. In an environment of high interest rates, a buyer may not be able to qualify for a full traditional mortgage. They may ask the sellers to carry back a second mortgage for, say, 10% of the purchase price. For a married couple, this is a standard investment strategy. For a divorcing couple, this is a financial nightmare. A seller carryback means that even though the house is sold, Michael and Sophia remain financially tethered to each other as co-lenders for the next 5 to 10 years. The specialized agent analyzes the potential outcomes of a carryback with extreme caution. They must ask, who collects the payments? How is the 1,099 INT interest income reported to the IRS? What happens if the buyer defaults and the property must be foreclosed upon? In a 2026 divorce context, the agent usually coordinates with the attorneys to create a formal note and deed of trust that is serviced by a third-party professional. This third party collects the single payment from the buyer and automatically splits it into 2 separate deposits for Michael and Sophia. This removes the need for the former spouses to interact or depend on each other for their monthly income. Furthermore, the agent ensures that the legal agreement specifies which spouse has the right to initiate foreclosure proceedings if the buyer stops paying. Without these step-by-step details, a seller carryback is a ticking time bomb that can explode long after the divorce is finalized. Another critical component of the terminal protocol is the closing of the file and data retention. In the US, statutes of limitations for real estate claims can vary, but the professional standard in 2026 is to maintain a forensic file for a minimum of 7 to 10 years. This is not just a folder of contracts. It is a repository of every communication that occurred during the transaction. For a divorce specialist, this includes the evidence locker. This locker contains the timestamp 3D scans of the property taken during the listing appointment, the neutrality logs of every decline showing, and the specific written instructions received from the opposing attorneys. Imagine if, in 2029, Michael is audited by the IRS or sued by Sophia for a breach of their marital settlement agreement related to the house sale. The real estate agent may be subpoenaed to testify or produce records. A standard agent who has deleted their emails and tossed their paper files will be a useless witness, potentially leaving their former client vulnerable. The specialist, however, can produce a digital trail that proves exactly what was known, when it was known, and who authorized every decision. This level of professional integrity is what prevents the agent from being named as a co-defendant in a malpractice or negligence suit. We must also analyze the psychological phenomenon of the post-sale regret. In 2026, as the market shifts, a spouse may see the home they just sold for $800,000 listed for $950,000 6 months later by a flipper. They may suddenly blame the real estate agent or their former spouse for an undervalued sale. The specialized agent mitigates this by ensuring that the final sales price was supported by a court-approved valuation at the time of the contract. By having the judge or the attorney sign off on the price before the deal is finalized, the agent creates a legal shield against future claims of negligence or underselling the asset. The end of Part 9 brings us to the realization that a divorce real estate transaction is a high-stakes surgical procedure. The agent has successfully separated the conjoined interests of two parties, navigated the financial and legal minefields, and delivered the proceeds. But as the file is finally locked away, we must zoom out and look at the broader impact of this specialization on the American legal and real estate landscape. What is the future of this niche in a world of increasing domestic volatility? How does the rise of artificial intelligence and automated valuation models in 2026 interact with the deeply human, high-conflict nature of divorce? And most importantly, what are the final universal lessons that every homeowner in the USA must learn from these case studies to ensure that their most valuable asset never becomes their greatest liability? In the final part of this masterclass, we will conclude our academic discourse by exploring the systemic evolution of the divorce real estate industry, the ultimate checklist for the divorcing consumer, and the philosophical shift required to turn a marital ending into a successful financial beginning. We will look at the final resolution of our case studies and see where the path of professional neutrality leads when the dust finally settles. The transition from the distribution of proceeds to the absolute termination of the listing file is where many standard real estate practitioners make their most significant errors in risk management. In the academic study of United States real estate law, there is a concept known as the long tail of liability. This refers to the period after the closing during which the sellers remain legally exposed to claims from the buyer regarding non-disclosure, misrepresentation, or breach of contract. In a 2026 high-conflict divorce, this tail is not just long, it is barbed. Because the sellers are often no longer on speaking terms, a post-closing lawsuit can act as a proxy war, dragging both parties back into the courtroom for years. The professional divorce real estate agent must implement a terminal protocol that insulates the parties from these potential outcomes, while simultaneously protecting their own professional standing. To understand the mechanics of post-closing liability, we must first dismantle the myth of the as-is sale. In many 2026 transactions, divorcing couples insist on listing the property as is to avoid the cost and conflict of repairs. However, in the U.S. legal framework, as-is does not mean without disclosure. Imagine a case study involving a couple named Michael and Sophia in Miami, Florida. During the 2026 hurricane season, a small leak developed in the secondary bedroom. Michael, who was living in the home, patched the ceiling with paint but did not perform a structural repair. Sophia, living elsewhere, was entirely unaware of the leak. They sold the home as is to a young family. 3 months after the closing, a major storm reveals the structural damage, and the new owners sue for fraudulent concealment of a material fact. In this scenario, Michael and Sophia face joint and several liability. This means the buyer can pursue either or both of them for the full amount of the damages. If Michael has already spent his share of the proceeds on a new business venture, while Sophia has her share sitting in a high-yield savings account. The buyer's attorney will likely target Sophia's liquid assets first. Sophia then has to sue Michael for indemnification, a legal process that can cost more than the original repair. The specialized divorce agent prevents this by insisting on a comprehensive seller property questionnaire and a real estate transfer disclosure statement that is signed by both parties. If Michael refuses to disclose the leak, the agent's neutrality log becomes the primary evidence. The agent documents that Michael was asked specifically about water intrusion and denied it. This shifts the liability away from the innocent spouse and the agent, providing a clear map for the legal teams to follow. Beyond the physical condition of the home, 2026 has seen a resurgence in a complex financial maneuver known as the seller carryback, or seller financing. In an environment of high interest rates, a buyer may not be able to qualify for a full traditional mortgage. They may ask the sellers to carry back a second mortgage for, say, 10% of the purchase price. For a married couple, this is a standard investment strategy. For a divorcing couple, this is a financial nightmare. A seller carryback means that even though the house is sold, Michael and Sophia remain financially tethered to each other as co-lenders for the next 5 to 10 years. The specialized agent analyzes the potential outcomes of a carryback with extreme caution. They must ask, who collects the payments? How is the $1,099 INT interest income reported to the IRS? What happens if the buyer defaults and the property must be foreclosed upon? In a 2026 divorce context, the agent usually coordinates with the attorneys to create a formal note in deed of trust that is serviced by a third-party professional. This third party collects the single payment from the buyer and automatically splits it into 2 separate deposits for Michael and Sophia. This removes the need for the former spouses to interact or depend on each other for their monthly income. Furthermore, the agent ensures that the legal agreement specifies which spouse has the right to initiate foreclosure proceedings if the buyer stops paying. Without these step-by-step details, a seller carryback is a ticking time bomb that can explode long after the divorce is finalized. Another critical component of the terminal protocol is the closing of the file and data retention. In the U.S., statutes of limitations for real estate claims can vary, but the professional standard in 2026 is to maintain a forensic file for a minimum of 7 to 10 years. This is not just a folder of contracts. It is a repository of every communication that occurred during the transaction. For a divorce specialist, this includes the evidence locker. This locker contains the timestamp 3D scans of the property taken during the listing appointment, the neutrality logs of every decline showing, and the specific written instructions received from the opposing attorneys. Imagine if, in 2029, Michael is audited by the IRS or sued by Sophia for a breach of their marital settlement agreement related to the house sale. The real estate agent may be subpoenaed to testify or produce records. A standard agent who has deleted their emails and tossed their paper files will be a useless witness, potentially leaving their former client vulnerable. The specialist, however, can produce a digital trail that proves exactly what was known, when it was known, and who authorized every decision. This level of professional integrity is what prevents the agent from being named as a co-defendant in a malpractice or negligence suit. We must also analyze the psychological phenomenon of the post-sale regret. In 2026, as the market shifts, a spouse may see the home they just sold for $800,000 listed for $950,000 6 months later by a flipper. They may suddenly blame the real estate agent or their former spouse for an undervalued sale. The specialized agent mitigates this by ensuring that the final sales price was supported by a court-approved valuation at the time of the contract. By having the judge or the attorney sign off on the price before the deal is finalized, the agent creates a legal shield against future claims of negligence or underselling the asset. The end of Part 9 brings us to the realization that a divorce real estate transaction is a high-stakes surgical procedure. The agent has successfully separated the conjoined interests of 2 parties, navigated the financial and legal minefields, and delivered the proceeds. But as the file is finally locked away, we must zoom out and look at the broader impact of this specialization on the American legal and real estate landscape. What is the future of this niche in a world of increasing domestic volatility? How does the rise of artificial intelligence and automated valuation models in 2026 interact with the deeply human, high-conflict nature of divorce? And most importantly, what are the final universal lessons that every homeowner in the USA must learn from these case studies to ensure that their most valuable asset never becomes their greatest liability? In the final part of this masterclass, We will conclude our academic discourse by exploring the systemic evolution of the divorce real estate industry, the ultimate checklist for the divorcing consumer, and the philosophical shift required to turn a marital ending into a successful financial beginning. We will look at the final resolution of our case studies and see where the path of professional neutrality leads when the dust finally settles.